For the last few years, we've gathered here to remark upon what a blockbuster term the court had just concluded. So while blockbuster isn't quite the right word to describe the October 2016 term, it certainly wasn't business as usual. With Justice Scalia's seat vacant for 2/3 of the session, Merrick Garland's nomination obstructed in the Senate, and the ensuing battle over now Justice Neil Gorsuch's nomination, there was certainly plenty of Supreme Court watching to be done. On that note, I'd like to draw your attention to a new ACS issue brief that's available right outside today and on our ACS website that's authored by Professor Kermit Roosevelt and Ruth Helen Vasilis from the University of Pennsylvania Law School, in which the authors reflect on the acrimonious process of filling Supreme Court vacancies and propose that we can fix the problem by instituting term limits on Supreme Court justices by statute. So I commend it to you, and perhaps that can form some kind of context for the conversation we're going to have today. But turning back to this term, I don't mean to suggest that there weren't important cases on the docket, from redistricting to race and criminal procedure, church-state separation and immigrants' rights. The court handed down a number of cases that will impact the lives of many. And of course, now we have the travel ban cases to look forward to this fall. So to lead us through the discussion today with our distinguished panel, we have a true expert on the Supreme Court and a friend to ACS, Tom Goldstein. Tom, as you know, is one of the nation's most experienced Supreme Court practitioners. He has served as counsel to the petitioner or respondent in roughly 10% of all the court's merits cases for the past 15 years, personally arguing 40. In addition to practicing law, Tom has taught Supreme Court litigation at Harvard Law School since 2004, and previously taught the same subject at Stanford Law School for nearly a decade. He's also the co-founder and publisher of a blog that I know we all read avorously every week, every day, which is SCOTUS blog, the only weblog ever to receive the Peabody Award. And in 2010, the National Law Journal named him one of the 40 most influential lawyers of the decade, and Legal Times named him one of the 90 greatest Washington lawyers of the last 30 years. So who better to navigate us through these waters? Please welcome Tom Goldstein.
Thank you all so much. On behalf of all the panelists, we want to really voice our appreciation for your taking the time to come here. It becomes apparent as the tides continue to flow at the Supreme Court that being aware of what's going on at the court, the developments in the law, the trajectory of the law becomes even more important. And so the fact that you all have invested your time in studying the court and to come here is a very significant thing. ACS plays, of course, an incredibly important role in that process as a forum, as a vehicle for thought about progressive possibilities in the law. And so it's a great opportunity each year for us to come together and talk about the term. This is really a retrospective on the term. And so while there are a lot of developments coming up, it was a really important transitional time at the court, of course, a time where the law could have cut in one direction or another. And it's important to take the cases from this term, including the ones at the end of the term that Justice Gorsuch participated in, and get a real feel for where the court is going and what it means for the law and for the Constitution and the like. And then we are going to make sure that we leave time for two things towards the end. The first is to talk about the travel ban, to have some sense looking forward, because there was, in fact, an order this term with respect to the travel ban, of course, and that is regarding the scope of the injunction, and it's obviously something that's literally about to go into effect. And we also want to make sure that we have time for your questions, and so we're going to leave 30 minutes for that. As a consequence, I'm extremely mean when it comes to timing, and I hope you'll, and the panelists will forgive me for that, because everybody has such important things to say. I want to make sure that we stick very closely to our time. The bios of the speakers are in the materials that you have, I know, and are available to you, and so I'm going to be relatively concise in introducing people just so we can get straight to the substance, but I think you'll see that we happen to have incredibly sophisticated and experienced subject matter experts with respect to the topics of the cases that were decided this term. And so maybe we'll start with Lee. Lee is a senior staff attorney with the ACLU, and also in that role has particular responsibility for First Amendment matters. Leah also teaches at NYU, and so you're going to take us through the First Amendment docket?
Sure. Number one is number one, I guess. So I'm going to talk about 3 cases that were First Amendment cases, or at least called First Amendment cases by the court. And each of them is 8-0, but the far more interesting fact is that surface and unanimity masks much more turbulent waters underneath. None of these are simple cases. They all have multiple opinions and concurrences, some of them quite spicy. And so I think it's far more interesting than just the fact that they were all 8-0 cases that came out in favor of First Amendment claims in all 3 cases. There's clearly some deep confusion and disagreement about how the court should evaluate different kinds of First Amendment claims. So I'm going to start with what I think is in some ways the simplest one, which is Packingham versus North Carolina. Came out last week, well, maybe 2 weeks ago now, on the 19th. And Packingham was a case that was appealed from the North Carolina Supreme Court, which had approved a law that forbade all registered sex offenders from accessing any website that permitted children to open an account. And there was no requirement that there would be actual contact with the minors. It was just a blanket ban on all these websites. And while it wasn't exactly clear what it reached, the court assumed it reached sites like Facebook, Twitter, and LinkedIn, which it noted are integral to most people's daily lives at this point. One note that I can't resist is that Packingham comes down almost exactly 20 years to the week after Reno versus ACLU, the pretty famous 1997 case that established that the First Amendment fully applies to this digital realm, whatever it is. And so it's lovely in some ways because it reaffirms a lot of that highfalutin language about the internet being this incredibly important medium for communication. But what's interesting about the case in which the court 8-0 struck down this law as a unprecedentedly broad restriction on First Amendment speech is that Kennedy joined the liberals in an opinion for the 5 of them that really starts out by talking about forum doctrine. It starts out discussing the internet in the context of streets and parks, things that we think of as the quintessential public forums. He doesn't make its holding precisely a forum case, but he relies on a case called Jews for Jesus, which prohibited all First Amendment activity in an airport, which is, again, a forum case. And so in the concurrence drafted by Alito says, he calls the opinion by Kennedy in his first paragraph, undisciplined dicta, musings, and unnecessary rhetoric. He's obviously quite pissy that anyone would start applying forum doctrine to the internet. And so I think this case is really interesting because it's showing the cracks and the limits in the forum doctrine in our digital age. And in Kennedy's opinion, so fascinating, this is reading from the opinion, on LinkedIn, users can look for work, advertise for employees, review tips on entrepreneurship. On Twitter, users can petition their elected representatives and otherwise engage with them in a direct manner. Indeed, governors in all 50 states and almost every member of Congress have set up accounts for this very purpose. So he's actually kind of, I think, flagging for us the idea that the government is interacting in this forum in a way that is making him question how we think about the internet. And especially with a lot of recent talk about government officials, including Trump, blocking people on Twitter, this is a paragraph we should be paying attention to. So it's an interesting case, reaffirms all that beautiful language about the internet not being immune from First Amendment review, and it's worth a read. By the way, what the convicted sex offender said online was after he got out of a traffic ticket, he went on Facebook and said, "God is great, praise Jesus." That's what he was convicted of a felony for saying. I think sometimes good facts make good law, and that might play a part here. So the second case is Expressions Hair Design. I admit to finding this a bit of a goofy case, with my apologies to any litigators as part of this. And the ACLU generally files an amicus brief in pretty much every First Amendment case that comes before the court. We didn't file in this case. And one of the reasons, I think, as I explained the opinions, is that I'm not sure we were all convinced this necessarily should have been a First Amendment case. This is probably the least sexy of the 3 First Amendment opinions and has gotten the least media. And it's about a New York business law that banned credit card surcharges. What that means is certainly open to interpretation, including after the Supreme Court's opinion. But many businesses, New York businesses, challenged the law, saying that what it did was effectively impose a semantic regime, which is that they could give a cash discount, which would charge a customer the exact same as a credit card surcharge, but they couldn't call it a credit card surcharge. You may not be surprised to know that the credit card companies were in favor of this law. Basically, the Second Circuit had said, there's no speech here, this is just business regulation. And again, in an 8-0 opinion by Roberts, Roberts said, no, because it's so nonsensical, all it does is require you to explain the surcharge in a certain way. That's a speech regulation. And look, I don't know what kind of scrutiny that you get, if it's Central Hudson, if it's Zouderer, which applies to disclosures. So we'll remand to clean that up. But I know a speech regulation when I see it. This gets First Amendment scrutiny. It should go back to the Second Circuit. Breyer agreed, but he kind of has this, if you've ever listened to an oral argument, not a surprising concurrence, where he says, this speech conduct distinction doesn't always work. Can we just go back to thinking about whether or not this targets political speech, which is what the First Amendment should really be about? And I'm not sure it does, but this is a dumb law, so I think I'd remand too. And then Sotomayor, hilariously, I think, because she's clearly very worked up, in the first bit of her concurrence, she says, the court assumed a bunch of things and issued an unnecessary constitutional opinion that's not particularly helpful. And she says, this quarter loaf is better than if we'd said nothing at all. So obviously she doesn't like the opinion, but she concurs too. What the heck, send it back to the Second Circuit. Her view is that it should be sent back to the Second Circuit for certification to the New York Court of Appeals to determine what this law actually means. And so really there's kind of a series of definitional fights, but what's very interesting is that the Roberts portion of the court was willing to assume that a commercial regulation affected speech. And here, what I'd highlight for everyone is I think what Breyer and Sotomayor may be reacting to are their concerns about the conservative members of the court turning the First Amendment into a new Lochnerizing tool to strike down business regulation. And the Roberts opinion is perfectly happy saying, we're looking at the First Amendment here. And now, with I think 1 minute to go, I will quickly gloss the most interesting, complex, and certainly impossible to describe in 1 minute case that came out of the court, Mittal v. Tam, previously known as Lee v. Tam, in which the court again 8-0 struck down Section 2A of the Lanham Act, which was part of the trademark law that forbade the Patent and Trademark Office from registering any trademark which disparaged or brought into disrepute any person living or dead, and by the way, any institution, belief, or national symbol. So end the Fed or Yankees suck, absolutely under the text of the statute would have qualified. Tam, the petitioner, was the front man and bassist of a group called the Slants. They were all Asian American. The Patent and Trademark Office Googled them in deciding whether to register their trademark, found out they were Asian, and said, oh, well, this must be a slur, and denied it. After making its way through a masterful series of decisions, including a sua sponte vacation at the en banc Federal Circuit, the case went up, and the court, again, 8-0, masks this crazy split between 4 and 4. We have Alito, Roberts, Thomas, and Breyer on one side, and we have Kennedy, Ginsburg, Sotomayor, and Kagan on the other. And you know what? I'd be hard-pressed to tell you exactly what doctrinal differences they have. They seem to all agree that this is private speech. Alito said, God, if this is government speech, the government is babbling prodigiously and incoherently, which is certainly true, right? Nobody is thinking, oh, this is a government Saratoga. That's delicious, right? So everyone agrees on that. That's a no-brainer. And they all agree that it's a viewpoint-based rule. And I think what's really going on here is the court, particularly the Alito opinion, is really interested in limiting the spread of the Walker case, which came out last term, or 2 terms ago now, and basically said that a specialty license plate was government speech. And I think the justices recognize that allowing the government to offer a benefit and transition private speech to government speech allows a massive amount of viewpoint-based regulation. So everyone pretty much agreed that was wrong, but the opinion written by Kennedy much more focused on the government's disapproval of an individual viewpoint rather than whether or not this was government speech or a government program, which is what the Alito opinion really focuses on. So again, it's more in tone, but you can see that even when they're closely aligned, they just refuse to get on the same opinion on a First Amendment case. And so it's interesting for that reason. There's way too much to unpack in that, but I'd be happy to answer any questions and do my best to do so later.
Terrific. Thank you so much. Next will be Peter. Peter is co-chair of the appellate practice at Davis, Wright, and Tremaine. And before that was the deputy GC at the FCC, where he obviously had a lot of responsibility for litigation involving communications and speech. And so for that reason, I think you may have some thoughts on the First Amendment case.
Just a few quick observations. I think it's not always easy to sort of tease out a theme from a small sampling of cases, but one thing I think we do see here is continued muscular assertion of the First Amendment. And a couple of, one thing that jumps out at me off the bat is here you have the Supreme Court facially invalidating two statutes, a federal statute that had been in effect since the 1940s and the state statute in the North Carolina case. It's noteworthy that in the Tam case, the court had two theoretical easier ways out that would have been short of a facial invalidation. First off, there was a statutory argument that Mr. Tam put forward. Now, conceitedly, I think it was a real stretch, and the court saw it as a stretch, but in theory, it could have gone for a statutory holding, but chose not to. Perhaps more on point, one of the members of the Federal Circuit had said, okay, why don't we say that the application of this statute to Mr. Tam's proposed trademark is unconstitutional? He was seeking to basically repurpose the mark and reclaim it in a way that was not derogatory. And why don't we find that unconstitutional as applied, but just sort of let the statute stand for another day? And it's noteworthy the Supreme Court did not go for that. They struck down the whole statute. A couple of other things that jump out at me. I think we see a pretty broad conception of viewpoint discrimination that all justices, all 8, signed on to. And that seemed noteworthy to me because I think the government had a non-crazy argument. I don't think it was necessarily the right argument, but the non-crazy argument that this was content-based discrimination, not viewpoint-based. And the idea basically was this statute has a non-disparagement provision. That doesn't say you cannot disparage certain particular views. It just says don't disparage anyone. So, don't disparage Republicans, don't disparage Democrats, don't disparage capitalists, don't disparage socialists. And there's been a kind of continuing, lingering confusion on sort of what the guidepost is between content-based discrimination and viewpoint-based. And viewpoint-based is the most pernicious type of discrimination that always triggers strict scrutiny, basically in any context except for government speech, and we can get to that. So it was interesting to me that you had all 8 justices saying, yeah, this is viewpoint discrimination. And again, along the lines of sort of the good facts make good law, bad facts make bad law, that may be an aspect of this case that has broader ramifications. My personal speculation is if that sort of legal question could have been surgically removed from the facts of this case, I don't know that you would have gotten 8 votes for that proposition of law. So that's another interesting thing that sort of obviously weighs in favor of a strong assertion of the First Amendment. And then the other is one alluded to a bit earlier, which is the cutting back on a broad conception of government speech. And I think that was really Justice Alito having some fun with having come out on the wrong end of the Walker case involving the Texas special license plate system. Where he said, look, this isn't a government program. You can put basically any crazy thing on a license plate, and who is going to think that the government is sort of putting its seal of approval on that? And he put forward now in the majority opinion in Tam similar sort of hypotheticals to say, look, no one's going to think this crazy trademark is endorsed in some fashion by the government just because it has set up a registration scheme. So I do think that signals some caution about how the government speech doctrine, which is basically immune from First Amendment review, if it is framed too broadly, can suppress a great deal of speech. And then just the final point is I think we're seeing some signs of continuing aggressive a review of restrictions of commercial speech, Justice Kennedy and 3 other justices would have applied so-called heightened scrutiny under a case Tom handled called Sorrell a few years ago to viewpoint discrimination expressly in the commercial speech setting. And there's again been some sort of lingering doctrinal confusion about whether the same sort of content-based and viewpoint-based triggers in the non-commercial speech setting apply with equal force in the commercial speech setting. So I think we're going to see some continued advocacy picking up on that, and even picking up on Justice Thomas's solo view that even content-based distinctions in the commercial speech setting fully trigger strict scrutiny, which would be a dramatic holding if it were endorsed by more justices.
And do you want to talk to us about constitutional torts of the court this term?
Sure, yeah. I can just briefly get into the Hernandez case and the other Bivens case. I think many of you will be aware of the facts of this one, so I won't dwell on them. This was the very tragic situation involving a 15-year-old Mexican boy who was fatally shot literally at the border, the US-Mexico border. He was playing with some friends. There's some dispute over exactly what was going on, whether he was running away from a Border Patrol agent, whether he was throwing rocks. But it seems undisputed he was unarmed. The Border Patrol agent shot him and killed him. His family brought a Bivens claim, in other words, a claim seeking damages against the federal agent who shot and killed him. And what had started out as a case hopefully raising this highly abstract question of to what extent the Constitution applies outside the borders. To what extent does the constitutional protections, including under the Fourth Amendment, reach to a non-citizen who is not on US territory and doesn't necessarily have any connections with the United States? That was sort of the prime question that the teenager's family put forward for the Supreme Court. And the case kind of morphed into a Bivens case, namely whether there should be recognition of a damages remedy. And the court ultimately punted on that question. A 7-page per curiam unsigned opinion came out on the last day of term saying, you know what, the Fifth Circuit should just look at that whole question again under a test we set forth in this other case. That was the one involving claims arising out of the government's response to 9/11, where there was a sweep of mainly Arab and South Asian men on immigration violations. Several of them who were detained under harsh conditions in a detention facility brought suit under Bivens theory, and the court set forth a sort of new test for when to recognize a Bivens damages claim. And I think what a few takeaways from those two cases are, I think we see some strong distinctions between the justices over some fundamental ideas, one of which is what should be our baseline conception here. Is the baseline view basically the old kind of common law view, which Justice Breyer put forth in some dissents, that where there's a violation of a right, there should be a remedy? And we start from that premise and then we kind of figure out what happens next. Or do you start from the opposite premise, which is, well, we're going to assume there's no remedy unless it's set forth in a statute, and that is apparently the prevailing view. And this has been a sort of continuing movement the court has had over the last 3 decades or so against so-called implied right of actions. I would say that the very notion of an implied right of action, again, sort of accepts that premise that you start from step 0, which is there is no right unless it's expressly given. So we have some real big picture disagreement over sort of how we should look at this, and I think that bleeds into a separation of powers issue, which is, well, what's the best entity? Who should go about recognizing these sorts of rights of action or sort of creating them? Is this really a question for the courts, or is it a question for Congress? And very strongly, under the Justice Kennedy view that prevailed in the Abbas case, that's Congress, at least under prevailing doctrine, whereas I think from the Justice Breyer perspective, common law courts historically have protected rights. In his view, where there's a clear violation of a right, there ought to be a remedy, and courts are the entities that give effect to rights. So I think we'll probably continue to see the trend towards narrowing of Bivens remedies. but it does gloss over some very fundamental disagreements over the principles at issue.
Thanks very much. Anita is the executive director of the Southern Coalition for Social Justice, which works on an array of civil rights matters. And before that, was the deputy in the Civil Rights Division who was responsible for voting rights. And so will you talk to us about the voting and gerrymandering cases?
Yes, thank you so much. And thank you to ACS for inviting me here. I am going to talk about 4 cases that the court disposed of. 3 of them are from North Carolina. Only 2 of them were argued and have full written opinions. So so those are the redistricting cases, and then I'll say a quick word about another voting rights case that the court dealt with. But in the area of redistricting, all of these cases, all these 4 cases were cases following the Alabama Legislative Black Caucus decision from 2013, raising claims of racial gerrymandering, and racial gerrymandering that happened in the 2010 round of redistricting after the 2010 census. The 2 cases that were argued the same day. One from Virginia, the Bethune-Hill versus Virginia State Board of Elections case, where the plaintiffs challenged 12 of the delegate districts that Virginia drew. The lower court had found that in 11 of those districts, race did not predominate, but in the 12th, District 75, the court found that race predominated, but that it satisfied strict scrutiny. And so the issue was whether the trial court had applied the correct legal standard for the 11 districts, whether they applied the correct legal standard in determining that race did not predominate. And what the trial court did was say that we are going to only look where racial considerations override or come in conflict with traditional redistricting criteria. And probably, while the trial court listed 11 of those, compactness and the shape of the district is the main one. And so the court said if the district looks okay, if it's not a strange, bizarrely shaped district, highly non-compact, then we're not even going to consider whether race predominated. And the court fairly easily, I think, said that's not the legal standard. So just going back to the Shaw line of cases, back to Miller, and where the court very clearly said even compactness is just an element of proof that race predominated. It's a non-compact district is a way to help you prove that race predominated, but it's not, there's other ways. You can have direct evidence of racial considerations being the paramount considerations that are not compromised, and that they predominate over other considerations. But I do think that it was a further refinement of how do you prove race predominated, for the court to be very clear that conflict with other traditional redistricting criteria may be evidence of predominance, but it's not a necessary element of plaintiff's proof. Then a subsidiary question, which was, once you've decided that one, pretty easy to figure out, is did the trial court err in considering the legislature's racial motive only in the part of the district that conflicted with traditional redistricting criteria? So if you're looking at the part of the lines that look non-compact, do you have to show that that's where racial considerations made a difference? And the Supreme Court said you have to have a holistic view. You can actually, there might be statewide evidence that's relevant to whether race predominated in a single district. You're not limited to just where there's conflict with traditional redistricting criteria. And then for the district that was found to be where race did predominate, but it satisfied strict scrutiny, there the court affirmed this was a 7-1 decision. The court affirmed the trial court in saying that strict scrutiny was satisfied. And I think that it raises some interesting questions for legislatures going forward, because the level of proof was not all that high. In other words, the legislature didn't have in the record, there's no racially polarized voting study. They relied on looking at past election results, where there was one election where the candidate of choice of African American voters was won very narrowly. And then they listened to the opinion of the incumbent in that district, who said, yes, I need my district to be 55% black. And so on the one hand, because they were looking at what level of evidence do you need to have a sound basis for believing that this district was necessary to comply with the Voting Rights Act, it was Section 5 of the Voting Rights Act that they were trying to comply with, which will not, unless Congress does something in the next few years, will not be in effect for the next round of redistricting. And so I think there's a question of whether there's a higher level of evidence that you might need if you are looking to comply with Section 2 of the Voting Rights Act. But the dissent would have held that District 75 also didn't satisfy strict scrutiny because of the view that Section 5 is not a constitutional provision itself, and because the level, the evidence that the legislature was operating on wasn't sufficient. But for the most part, that was a resounding continuation of the notion that race should not be a predominant factor in redistricting. The Cooper case, which took the court a bit longer to decide, was a little more complex because there we're talking about, Cooper is about North Carolina's 1st and 12th congressional districts. And the courts had a lot of history with these two congressional districts because the original Shaw case was about the 1st and 12th congressional districts. But we had this history in North Carolina of, in the decade immediately prior to this redistricting, District 1 was 48% black, District 12 was 43% black, and they had both throughout the decade elected the candidate of choice of black voters, sometimes by as much as 70 and 72%, never dropping below 59 or 60% of the vote. So there was a strong pattern of candidates of choice of black voters winning in those two districts. But the legislature, when it started to redraw in 2010, said that because of the Bartlett v. Strickland case, even though we are trying to comply with Section 5 of the Voting Rights Act, and Strickland was a Section 2 case, because that case said that you have to have a 50% or greater illustration district to show a violation of Section 2, then we, in order to comply with Section 5, have to make these districts greater than 50%. So they drew both of those districts back up to greater than 50%. And the numbers in terms of moving black voters into the districts and taking white voters out were pretty stark. And District 12 was actually a district that was pretty much the right size. It only needed about 3,000 more people in a 750,000 person district. So there wasn't any other explanation for why you were moving these people except to bump the percentages over 50%. So with regard to the 1st congressional district, the state conceded, if you will, that it was drawn to comply with the Voting Rights Act. They had some arguments about why that still didn't mean race predominated, but the trial court found clearly that race predominated and that it wasn't justified by the past history of elections. There wasn't evidence in the record to support the need to do that. And the Supreme Court, on that question, the Supreme Court was unanimous that District 1 did not need to be increased and was a racial gerrymander. The tougher part for the court was District 12, where at least there were some contemporaneous statements during the redistricting process that District 12 was drawn to comply with Section 5 because one of the counties in that district is a Section 5 county. But the state is not, as a whole, is not covered, only 40 counties. And by the time this got to litigation in the Harris case, the state's defense was that that was drawn for political reasons, not for racial reasons, and so race did not predominate. And the defendant's argument was that following the Cromartie case, it was necessary for the plaintiffs to show that you could get the same political outcome, but not take race into account to the same degree in order to demonstrate that race predominated. And the court ultimately, 5 members of the court with Justice Thomas joining with the more liberal justices on the court, said that that may be a way to prove racial intent, but that's not the only way to prove racial intent. And there was plenty of evidence in this case. And there's a lot of interesting talk in the opinion about then Congressman Mel Watt and discussions he had with the legislative leaders at their home and who was lying about what was said. But the trial court credited Congressman Watt, said he was believable, and the Supreme Court said that this is a factual finding, whether race predominated. And and so ultimately affirmed the court below on both grounds. So the other two cases I want to mention quickly are, I think, notable. So the Covington case is a case from North Carolina about the legislative redistricting. 28 districts were found to be, by a 3-judge trial court, to be unconstitutional racial gerrymanders. And the court summarily affirmed 9-0. And I cannot find another racial gerrymandering case where the court has summarily affirmed districts as racial gerrymanders. There's some issues now about timing of remedy, but I think that's notable. And then the Dixon case, which is another case from North Carolina, a state court case. The racial gerrymandering claims had been combined with state law claims to challenge the legislative and congressional districts, and the court has twice now remanded from the North Carolina Supreme Court opinion and essentially vacated the North Carolina Supreme Court upholding those districts. And that became an issue in the Cooper case because the Supreme Court first had to decide, does that state court ruling, what weight should we give it, and does it mean that the plaintiffs in Cooper were barred from bringing their case? And the court did not think that there was privity under state law to bar the claims. In terms of what this means, I think for the most part, this is a continuation of the court's racial gerrymandering jurisprudence. I think it's clear that there is space between Section 2 liability and racial gerrymandering liability for legislatures to appropriately take race into account. The court was clear that simply drawing a majority-minority district to comply with the Voting Rights Act doesn't necessarily mean that strict scrutiny has to apply. Doesn't necessarily mean that race predominated. What's left to decide are the issues of partisan gerrymandering, which the court has said, yes, they'll take that up.
Tremendous, and maybe in the questioning we'll get a chance to talk about that case from next term. Paul is well known to everyone, is I think widely regarded, and rightly so, as the nation's most accomplished and effective appellate advocate and Supreme Court advocate. He's a partner at Kirkland & Ellis now. He was formerly the Solicitor General. Is going to talk about a number of cases, including state aid to religious organizations, and also start the conversation going forward to the travel ban.
Yeah, thank you, Tom. It's great to be here. I'm going to talk about a couple of cases that have nothing in common with each other, but I still think they are among the notable cases on this court's docket. I mean, you know, as everyone said, this was not a year for blockbusters, but it was a year where the court, I think, decided some interesting cases or decided some cases in interesting ways. And I think, in a sense, I have kind of one of each to talk about before I just briefly talk about the travel ban. So the first one, which I'll say is a case that the court decided in an interesting way, is a case involving insider trading, and the Salmon case. And for those of you that are less familiar about sort of insider trading regulation in the United States, I'll just give you the briefest sketch, which is, insider trading seems to me in the abstract the kind of thing that you'd like to have very clear rules about, so that if you're an insider at a corporation, there are certain periods when you can trade, certain periods when you can't trade. And if you're somebody who's in the securities industry, say you work at a hedge fund or something, there are very clear rules that, like, if you talk to an insider, you can't trade for 30 days afterwards, or whatever it would be. But you'd like some clarity, because on the one hand, we sort of want people in the securities industry to try to ferret out really, really good information. But if the information they get is too good, i.e. inside information, then it's what we call a felony. And generally in society, you like the line between what's socially useful and what's a felony to be relatively clear. Unfortunately, instead of having a variety of provisions that draw very clear lines, what we actually have regulating this area is good old 10b-5 and the general direction that no one shall engage in fraud in connection with the trade of security. And that works reasonably well with respect to insiders who are trading on their own accounts. It kind of is a very anomalous area of the law when it comes to essentially what people in the securities law industry refer to as tippers and tippies, and the liability for, say, a hedge fund person who's talking to somebody who's got inside information. And what's kind of weird about this is, in order to get the sort of insider trading prohibition to map up to the prohibition, the general prohibition on fraud, the court has essentially decided in a case from 20 years ago called Dirks, that the person who receives the information and trades on it is only liable if the insider themselves essentially defrauded the corporation for which they work. And you only do that if you give inside information, essentially knowing somebody is going to trade on it, and you give them that information for a personal benefit to yourself, to the insider. So that's the doctrine that was out there. The Second Circuit, in a case called Newman a couple of years ago, sort of changed the law in a way that had made the test for what is a personal benefit more demanding than I think had previously been understood. Then the Ninth Circuit came along in this particular case and essentially had a standard for what's a qualifying sort of gift or personal benefit to the insider that was less demanding and more favorable to the government. It was particularly kind of interesting detail here is that the Ninth Circuit opinion was not written by a sort of extant member of the Ninth Circuit, but was actually written by Judge Rakoff of the Southern District of New York, who had decided a number of cases applying the broader standard in the Second Circuit until the Newman decision trimmed back on it. All of a sudden, Judge Rakoff pops up on a Ninth Circuit panel and creates his own circuit split, which is, I got to say, that's a neat trick. So the court takes the case up, and there are all sorts of, because the law here, the underlying law is so general, there are all sorts of really, really interesting questions that are lurking in this area of the law, especially when you get to not just people who directly get information from an insider, but what people have called indirect tippees. So you have somebody who works at a hedge fund, they get a tip from somebody who works for a different hedge fund, they got that tip from somebody they had beers with a couple of days ago, and that person got the tip from somebody who's an insider. So what does like the third or fourth level tipper need to know about the personal benefit to the original tippee? Boy, I don't know. I mean, it's really hard questions, and all of those were lurking in the background, and in the particular context of the Salmon case before the Supreme Court, all the court really decided is if you give information to your brother, that's a personal benefit. That's the holding of the case. That got 8 votes in an area where I think if the court had tried to decide some of those other lurking questions that are going to be sorted out in the Second Circuit going forward and in other places going forward, I don't think the decision would have been 8-0 by a long shot. The only other thing I will say about this case is, even though it was 8-0, I do think this is a case where, particularly at the oral argument, you really notice the absence of Justice Scalia's voice. Because the court really didn't talk much about how sort of unusual it is that we have criminal liability turning on a statute that is exceptionally vague. And some of the concerns, and certainly the briefing tried to bring out some of the concerns that had motivated the case, the court in honest services fraud cases and the like, and you really just didn't have that voice at the oral argument in the case. And I'm not sure ultimately it would have made a difference in the way the court decided it so narrowly, but it really did strike me as one of the cases where I think the oral argument would, at least would have been very different if Justice Scalia were with us. So that was a case that I think was interesting, the way the court decided it so narrowly. The case that is genuinely interesting is the Trinity Lutheran case involving religious liberty. And I guess I would describe this as an important religious liberty case that the Supreme Court in the end found surprisingly, at least to me, easy to decide. The court in this case found there was a free exercise clause problem by a 7-2 vote. I found that particularly surprising because this decision had kind of an interesting procedural history before it got to the oral argument. This case was actually granted way over a year ago when Justice Scalia was still alive, and the court didn't schedule it in the April sitting of last term when it might first have been available to be scheduled. Then it didn't schedule it in October, November, December. I mean, so it seemed like something was clearly going on, and the easiest inference was that the court was really closely divided. And that's why they didn't decide even to schedule the case until April when they had a full 9-justice court. But then they decided, and both at the argument and in the ultimate decision, it looks like it's pretty lopsided 7-2 decision. I also think that it's a little bit surprising that the case was decided that way because probably the closest on-point decision the Supreme Court had had in this area about the interaction between state establishment clauses and the federal free exercise clause was a case by Locke v. Davey, which was decided 7-2, essentially the opposite way. Now, again, a couple people have alluded to facts influencing decisions. This was a case where, the facts, I think, were very tough for the state, and it was the state's own darn fault, okay? Because the way they set up this program, they had a program that seems like a really kind of good government program. You take tires that people are done with, instead of burning them and hurting the environment, you shred them up and you make them available to playgrounds to make the playgrounds have nice soft landing places. Sounds great. What could possibly go wrong, right? But the state decided to set up the program where they took applications from anybody who wanted to apply. They applied completely neutral secular criteria to rank the applications, literally from 1 to 44. What are the best applications in terms of helping the most people? They had enough money for 11. They told a church-affiliated playground that you're number 5 on our list. But then they said, oh, but wait, you're religious. We can't give you any of the money. So no problem with standing. I was thinking about this in terms of a case like Fisher, Abigail Fisher, and applying to the University of Texas. The University of Texas, to its credit, did not admit her, and then after admitting her say, oh, no, actually, we can't admit you. And that would have avoided all the standing problems in the case, but it might have made the University of Texas lose. And in a similar way, by the state of Missouri essentially saying, you're in, oh, wait, you're out. They created a case that I think at least 7 justices of the court found very easy to decide. Of course, in terms of the broader implications, it's all about footnote 3. If you go look at the decision, this is a plurality footnote attached to a majority opinion. And certainly Justices Thomas and Justice Gorsuch did not want to join footnote 3. I'm about out of time, so I'll simply read it to you because it doesn't seem like the kind of prose that should get Supreme Court justices disagreeing with each other, but here it is. Quote, this case involves express discrimination based on religious identity with respect to playground resurfacing. We do not address religious uses of funding or other forms of discrimination, end quote. That sounds pretty unobjectionable and generic, but there it is. So, I urge you to read the separate opinions, which in some respects are even more interesting than the majority opinion, where they fight about both the sort of scope of that footnote, what it means, and what it means for subsequent cases that are waiting in the wings. And with respect to the travel ban, I'll just say, if you're thinking about a good way to think about the transition from this last term, where it was kind of sleepy and they decided a lot of things with 8 justices and didn't make any waves, and you're thinking about the transition to next term, where they're back to 9 and things are back to front page news. The fact that they ended the term by essentially first saying we're going to let the travel ban go into effect except with respect to certain individuals, and there's nothing in the text of the executive order that says anything about it, but we're just going to do it as part of imposing, essentially lifting the stay in part. Very muscular and seemingly almost unanimous, although some justices didn't like the fact that they just didn't lift the stay in its entirety. But then setting the stage for a case that I think is going to be very closely watched and we'll be talking about in a year as one of the cases that make the next term full of blockbusters.
Thank you so much. Elizabeth is the president of the Constitution Accountability Center, which has played an increasing and incredibly important role in constitutional litigation around the country, including at the Supreme Court. And in particular, in using some of the tools that are generally associated with kind of conservative analysis of the Constitution for progressive ends. And so maybe you can give us some thoughts on the travel ban and then a couple of other cases.
Yeah, absolutely. Thank you so much, Tom, and thank you to ACS for having me. It's always a pleasure. I think that the travel ban, the ruling, per curiam ruling, notably, it wasn't 9-0, it was per curiam, gave a little to both sides. Obviously, those of us who would like to see the ban struck down and blocked in its entirety, and here I should note that my organization, Constitutional Accountability Center, and Peter are co-counsel for members of Congress who argue that the ban is both an unconstitutional discrimination against Muslims driven by animus that's obvious by the context in which the ban was enacted, as well as a violation of the statutory prohibition against discrimination of people on the basis of their nationality. And so we obviously were disappointed that it didn't also keep in place the block on all people coming to the United States who wish to come to the United States from those 6 countries. You know, I think in particular of refugees who are trying to flee strife and war and may not have any connection with the United States except for the fact that we have always been a beacon for such people. So I would consider that to be a bona fide relationship with the United States in heart and principle and ideals. But that is going to be the big question that we look at tonight when the administration is able to implement this modified travel ban, whether or not the people who have gotten visas, who are seeking to travel here, are going to be considered to have a bona fide relationship with the United States, which is the words that the per curiam opinion used, saying that people who had such a relationship, such as having a spouse or a parent, or had already been admitted to an educational institution or had a lined up job, they may enter the United States. So I think we're going to see a lot of confusion initially, and then next term it will certainly be one of the blockbuster cases. But speaking of this term, I don't need to tell a room full of ACS folks that times are hard for progressives right now. I would say times are hard for our nation right now. So it gives me great pleasure to talk about 4 cases that were good news for racial justice and gender equality. And I know what you're thinking. I got lost on my way to the Ninth Circuit review panel. But no, it's actually true. And it's not because Judge Rakoff got some mystery seat on the Supreme Court to make all these things happen, although that is a very clever trick. But we do see some surprising progressive victories, even in what is an unquestionably conservative Roberts Court. The first 2 cases have to do with racial bias in the criminal justice system. And the first case, I think, is important, not perhaps for the doctrine, but for the important message it sends, particularly in the context we're seeing with police shootings and the lack of accountability in the justice system that we've seen just recently in all these tragic and horrible and outrageous shootings of particularly African American men, but also women of color as well. And that case is the Buck versus Davis case. It was, the facts of it are egregious, and I think probably a lot of you have heard of it. There was a so-called expert in Texas who would present testimony on the stand that a particular defendant should be eligible for the death penalty because he is more likely to be dangerous in the future, a factor that was required to get the death penalty in Texas, simply because of his race, correlating his race to future dangerousness. The Supreme Court wisely reversed a denial of a certificate of appealability, which if anyone does habeas law, 1, I'm sorry, but 2, I'm also with you. That is basically a standard of whether reasonable people could agree that this is a constitutional violation. How you do not think that this is, reasonable people could think this is a constitutional violation, I do not know, to be honest. But the Supreme Court, in an opinion written by Chief Justice John Roberts, very powerfully said that these types of stereotypes are pernicious and even in small doses can be toxic. That was language from Roberts' decision. The reason I think it won't be terribly important in terms of doctrine is because the facts are so incredibly egregious. And so, you want to say, if not here, then when would you find such testimony to be constitutionally ineffective, putting on such testimony to be ineffective assistance of counsel? But again, I think it's important, and I think it's important that Chief Justice Roberts wrote that opinion. Justices Thomas and Alito dissented, which will be a common theme in the cases that I'm talking about. Perhaps Gorsuch would have joined them, he probably would have, but he didn't participate in any of the cases I'm talking about. The second case, which I think is very important in terms of doctrine, is the Pena-Rodriguez case. And this case involved a claim of racial bias when several jurors came to the lawyers representing Mr. Pena-Rodriguez and said that another juror repeatedly made comments in the jury room before they convicted him about the Mexican heritage of the defendant, saying all sorts of stereotypical things about how he knew that it was a sexual assault case, that Mexican men have their way with women, and just all these offensive, biased statements. Now, normally there is what we call the jury non-impeachment rule, which is a very good rule that says that you can't use statements after the fact to then impugn a jury verdict, that preserves the sanctity of the jury box. But here the question was, when is racial bias such a problem, and the possibility of racial bias infecting a conviction, such a problem that we will pierce that veil of jury non-impeachment? And the court, in an opinion by Justice Kennedy, made clear that because our commitment to having a justice system that is not infected with racial bias is so important, it was worth piercing the veil of jury non-impeachment in that case. Chief Justice Roberts joined Alito and Thomas in dissenting, noting that there was going to be some issues about slippery slope. How do you decide, are there other comments that might be based on religion or gender sufficient to pierce the veil or not? But I think that is an important case, and we'll see effects going forward in the doctrine and the way that applies in jury cases going forward. The third case that I want to talk about is shifting from the criminal justice system to housing. The City of Miami case in which they sued big banks, Wells Fargo and Bank of America. And the question was whether or not the city could sue under the Fair Housing Act for the racially discriminatory, predatory lending done by these banks, where they targeted riskier investments, riskier mortgages, rather, to communities of color. The city's argument was because these resulted in foreclosures, it dropped our property taxes and also required us to have greater city services go to those areas. Justice Roberts, Chief Justice Roberts, somewhat rather surprisingly to me, it was a welcome surprise, provided the fifth vote with the more liberal justices to say that the City of Miami was within the zone of interest, was one of the aggrieved persons under the language of the statute who could sue under the Fair Housing Act. I was a little surprised that Justice Kennedy did not join that majority, particularly after he authored what I thought was a great opinion 2 years ago in the Fair Housing Disparate Impact case. The last case that I will talk about is a case about gender equality. It's the Sessions versus Morales-Santana case. And this was an interesting issue about different standards if you have two unmarried parents and one of them is a citizen and one is not. There were different residency rules that applied if your citizen parent was female or male. Basically, there was a more stringent residency requirement if your US citizen parent through whom you were seeking to get citizenship was your father. And the actual judgment was 8-0. It was written by Justice Ginsburg, but Justices Thomas and Alito, again, only concurred in the judgment. Why do I think they concurred in the judgment? Well, there was what I considered to be a fabulous portion of her opinion, which talks about in applying the heightened scrutiny test to the different gender treatment in this particular statute, cites Obergefell, the marriage equality case, saying that even something that might have seemed appropriate or not unconstitutional at one time has to be considered under conditions today. I was a little bit surprised that Chief Justice Roberts joined that part of the opinion. I was not terrifically surprised that Alito and Thomas then only concurred in the judgment. And I think it's particularly interesting to think about that Obergefell line and the fact that Roberts signed on to that when you look at the summary reversal in Pavon versus Arkansas, which was the same-sex couples trying to have both their names on the birth certificate. Arkansas said no. There, Chief Justice Roberts joined that summary reversal, which basically, to me, signaled that perhaps he is, even though he dissented in Obergefell, accepting that it is the law of the land and will apply it as such He did not join the dissents in that case. And there, Justice Gorsuch wrote the dissent, which was joined by Thomas and Alito. So I think that will set up, when we look at the cake shop case for next term, really this balance of how LGBT rights and equality will play out in the next term.
Thanks so much. All right, so we want to take, and we've really stayed on schedule remarkably for the first panel in history of any kind. Want to take the remaining 30 minutes to answer your questions. And maybe we'll get the opportunity to talk about, for example, what the current, the end of the term taught us about Justice Gorsuch, or some of the upcoming cases. So because this is being videotaped, we need to just ask for your patience. What will happen is if you'll just raise your hand, I'll identify you or pick someone out, and then someone will bring a microphone. And if you would be good enough to just tell us your affiliation, and then hopefully direct your question to a particular member of the panel, that would be great. So let's start that process. If anybody who has questions. Yes, sir. Hold on just a second.
Yes, my name is Stephen Spitz. I'd like to ask this of Anita Earls and Paul Clement, if you can, based on this term's redistricting cases, prognosticate about what the court might consider in the Wisconsin redistricting case, which is going to address presumably the issue of partisan gerrymandering and how it differs from racial gerrymandering.
I'm happy to go first. I mean, I'll sort of state for the record that I represent the state legislators, so they're not the principal party. It's the state. It's represented as the principal party, but I do represent the state legislature in Wisconsin in the case. So with that caveat, I do think that it will be a very closely watched case, and I think from the perspective of somebody who's represented some legislatures in redistricting cases, it is, even under the current rules where you don't really have a justiciable doctrine of partisan gerrymandering. I mean, the task that a legislature faces in the redistricting context is a very difficult one, because you can't violate the Equal Protection Clause, you can't violate the Voting Rights Act in certain jurisdictions, depending on where you are. You have to take affirmative steps to essentially come into compliance with the Voting Rights Act. The easiest thing at first blush would be to say, well, why do you keep redistricting? But of course, you need to redistrict, otherwise you violate the equal population principles of the Equal Protection Clause. So, every 10 years, state legislatures have to redistrict. They really don't have any choice. And then they have all of these various ways that they can embroil themselves in litigation, and not a lot of safe harbors. So against that backdrop, for the court to say that we're now going to have, on top of all those other restrictions on the extent to which you take party into account and partisan gerrymandering, I do think is going to be one of the certainly the arguments I'm going to make, and we've already made at the cert stages. That really does create an incredibly difficult task then for the state legislatures. On the other hand, though, I mean you do have this dynamic in the status quo where in a situation where I think everybody will acknowledge that partisan affiliation and racial identity, at least in certain places, are highly correlated. It's a little bit weird that you can, if you take race into account, you're headed for strict scrutiny, even if you're taking race into account in part for partisan advantage. But if you take partisan advantage into account, even if it has a racial impact, that's something that doesn't trigger any scrutiny. So, as I look at the case, I don't have a crystal ball to exactly how the court's going to resolve the case, but I think those are going to be some of the competing impulses they're going to deal with. On the one hand, are we going to have an administrable rule that's not going to be sort of impossible for legislatures to apply? But on the other hand, sort of there is this anomaly in the current, in the status quo that is also, I think, going to impel some of the justices to think, we have to do something here. So
my disclosure, I represent plaintiffs in a partisan gerrymandering claim filed against the 2016 remedial plan, congressional districts drawn in North Carolina. And we're bringing an efficiency gap claim based on the Wisconsin case. There are other plaintiffs in that same case or a different set of plaintiffs, the case has been joined, raising claims more like the Maryland case. So
What is an efficiency gap?
So the efficiency gap is a measure of partisan bias, if you will, that seeks to solve this problem of how do you give guidance to legislatures. And I think it's very akin to the one person, one vote, plus or minus 10% overall deviation, because you can say to legislatures, over the course of time, this is where most legislatures fall in terms of what the efficiency gap is a measure of wasted votes. It is not proportional representation, but it is a way to say, are these districts fair to each party? And I think it's something legislatures can measure. They can, before they enact a plan, and the court could have a standard that says, if you're above a certain gap, it's presumptively unconstitutional unless you have some justification. Was it geography? Was it something else? If it's below a certain measure, it's presumptively constitutional unless there's evidence that, in fact, you were attempting to achieve partisan goals in an unfair way. It's about keeping things fair for both parties. And I think, actually, the Harris versus Arizona redistricting Commission case is an indication of the court's willingness to say that partisanship, that in the sense of treating one party unfairly from the other intentionally, is not a legitimate governmental purpose when you're drawing districts. Because in that case, the court said if you deviate from one person, one vote for partisan reasons, if you make your districts different sizes because you're trying to advantage one party over another, that would not be constitutional. And that was in Larios versus Cox, but then Harris kind of reaffirmed that. So I think that's a little bit of a window of what this court might do. But I also think an interesting question is going to be whether they think this is an equal protection clause issue or a First Amendment issue. And does the efficiency gap measure First Amendment concerns in the same way that it does equal protection concerns? And I'll just tell you, those two different types of doctrine have enormous real-world differences. Differences for who would have standing, whether you're challenging a single district or the entire plan, what's the nature of the harm, how you remedy the harm. All of those things are different depending on whether you have an equal protection framework or a First Amendment framework.
I mean, I do think the case is an illustration of how a single U.S. Supreme Court case can just reshape the United States conceivably. You're talking about a rule that would determine whether you can set up, for example, congressional districts to always favor Republicans or always favor Democrats, and that just echoes throughout all of American law. And right now we have a situation where Justice Kennedy, in the last case in which this came up, said, and he's the pivotal vote here, said, I can't find an administrable standard. And so I guess the question is, has his thinking evolved on that? Do you have a set of facts that would attract him this time? And do you all take anything from the fact, though, that the lower court had issued an order, found a partisan gerrymander, had issued an order, a remedial order, but the U.S. Supreme Court stepped in and put that on hold?
I'm sure we have different views on that. I mean, we think that that's not necessarily an indication of where the court's going to go.
Yeah, and honestly, I'm not sure our views are that different on that. I mean, I'm sure we could find plenty to for our clients to disagree with on the merits, but I don't think the remedial order that the court imposed and the time deadlines that it imposed, I don't think made a lot of sense once the court was going to at least defer jurisdiction and consider the case. Because I just think objectively the idea that you would make the Wisconsin legislature go and redraw all the districts based on this efficiency gap theory when the Supreme Court's in the process of considering whether that's even a justiciable theory, I mean, that doesn't make a lot of sense. So maybe one way of thinking about it is, I thought the Wisconsin government, supported by the Wisconsin legislature, had a pretty good argument for why, sort of staying the remedial order made a lot of sense. And because it was such a good argument, I'm not sure you can read a ton into the fact that they accepted it.
Sure. All right, next question. Ken?
Ken Jost, Supreme Court Yearbook, and Joe Stone Justice. Any number of people have already commented on the historically high degree of unanimity on the court, in the court's decisions this term. I wonder if those of you who follow it really closely would make any observations about that that seem pertinent. And I wonder whether you think it's a ticket for one term only, or whether there will be consensus building next term as well.
Folks, Elizabeth, Henry?
Yeah, I mean, I think, there was a remarkable degree of consensus this term. I think because for most of it, they were working shorthanded with only 8 justices, a situation that I think was unfortunate and unprecedented and irresponsible and all of that by the fact that they held that seat open so long in the hopes that a Republican would win the presidency, and of course he did. So I don't think that the consensus is necessarily, as I think Lee pointed out, sometimes the unanimity can mask disagreement even when they came to the same ultimate judgment. I think the other thing is that we just didn't see the kind of huge blockbuster cases we'd seen in the past that were very closely divided. I know a lot of us have said, well, that's because they shied away from them because of the fact they only had 8 justices. But I tried to think about what cases I think they should have taken that they didn't because of the shorthanded court, and I'm not really sure that that is true. So I think it's just one of those times. We're so used to having the term of the century that the fact that this one was just a little bit more of a regular Supreme Court term might seem like, oh my gosh, it's so unusual. I will say one area where I think is notable is that Constitutional Accountability Center has tracked the success of big business interests in the Supreme Court by monitoring how well the Chamber of Commerce, which considers itself the voice of business in litigation, does in the Supreme Court. And we have found overall that the Roberts Court is the most pro-corporate in the modern era. But this term, the Chamber had a whopping 80% success rate in the Supreme Court. So that, I think, is a remarkable consolidation of power for the business lobby in the Supreme Court this term.
Yeah, I think one of the things that's going on is what we would call the left on the court is trying to be relatively tactical and accommodate what they think is the inevitable pivot of the court, still further to the right. And so you get some of these things like 7-2 decisions where you have a Kagan or Justice Breyer or both participating in the majority and maybe trying to build some sort of consensus. I think that going forward, the court is going to be, and so this term, so 2 terms ago when Justice Scalia passed, you got down to 5%, 5-4 decisions. This term, you get closer up around 20. It's sort of gravitating back towards the normal numbers. But I would say that I think it's extremely likely that over the next few terms, you will get historically high, ideologically fractured 5-4 decisions. And I think that's true in part because of the nature of the cases that are coming back. I mean, there just wasn't a lot of ideological excitement this term. But also I think that Justice Gorsuch brings a renewed, strong conservative energy that actually with Justice Scalia had kind of passed for 2 reasons. The first is that Justice Scalia, I think kind of later in his tenure at the court was kind of less aggressive on some things. And also, in fact, when it came to things like the 4th Amendment or the Confrontation Clause, was actually joining together with the left on a number of these issues. Whereas I think with Justice Gorsuch, you were going to see a down-the-line doctrinaire conservative to the right of Justice Alito even. And so I just think you're going to have just more force and energy. And against that, I think the left will tend to get its back up. And so I think that those numbers are going to spike considerably, probably.
One thing that occurs to me, just as a follow-up on that will be very interesting to see is how strong precedent counts in Justice Gorsuch's thinking when he would disagree with a proposition if he was sort of taking it from a clean slate, because Justice Scalia did actually place considerable weight on precedent, and there were many issues where he made it clear he disagreed with a certain approach, but he just thought that had been resolved and he was prepared to follow the precedent. And Justice Thomas obviously has a very, very different view of that. He's on the other end of that. So I think we'll have to see how Justice Gorsuch approaches that sort of conundrum.
I mean, I think the first signals of that are not good from the, I'm thinking particularly of the Pavon case, although there are a couple others where he wrote the dissent. And if you take seriously Obergefell and the suite of rights, equality, and dignity that go along with that, to dissent from the summary reversal in such an obviously wrong case where you can have if you conceive of a child through artificial insemination and you can have the one spouse's name on if it's a opposite sex partner and not if it's a same sex partner, that's obviously a violation of Obergefell if you take seriously that precedent. So I feel like that is a bad sign for his professed commitment to precedent, which he said at his confirmation hearing. I think also the fact that he was, said many times in response to senators that he would be independent, he would not be a rubber stamp on Trump's agenda, even though he put him forth to the bench. And as we know, Trump likes his judges to do what he likes. The fact that Gorsuch would have allowed the entire travel ban to go into effect, I think shows that he fails that first test of independence from Trump.
Yeah, I'm not sure that I would infer the latter, other than that he's just super duper conservative, but we shall see. Next, anyone else?
Mark Swillinger, question for Tom and for Paul, although anyone else might have knowledge about it as well. I'm interested in your take on the decision to take the PASPA case in New Jersey, saying PASPA violates the Constitution and the freedom of states to regulate in the gambling area, what it means for that they took that case, and just thoughts on which way it might go.
Paul knows a lot about this.
I do, and I thought we wrote, a pretty effective brief in opposition, and the court took the case. I think there's a couple of thoughts, but this just, again, in the interest of full disclosure, I represent the sports leagues, the 4 professional sports leagues in the NCAA in this case. But the question at this point is, really the constitutionality of a federal statute that essentially limits the ability of states to sponsor and authorize gambling on sporting events. And I guess what I would say is, on the one hand, this could become a very important or potentially very important federalism precedent from the court. That's certainly the way that the state of New Jersey is going to want the court to sort of think about this. On the other hand, part of our experience with this case to date has been that this is just a really interesting case. I mean, people like sports. People like at least either to gamble or think about gambling. And people like to think about federalism. And this is just, this is like it's like to use a gambling term, it's a trifecta. And so, what happened in the Third Circuit is, we prevailed in having a majority of the court say there wasn't any federalism problem here. And then the Third Circuit took it en banc. And of course, at that point, as a logical litigant, you're thinking, boy, we might be in trouble here because, why else would they take it en banc? And then we ended up, prevailing in the en banc court something like 9-3. So, I guess I'm hopeful that maybe, what this signals is just that this is a really interesting case, and maybe doesn't signal that, that 5 justices are ready to sort of, add to the federalism jurisprudence in a way that would threaten PASPA. But, stay tuned. I think it'll be a very interesting case to watch next term.
Yeah, I think that there's got to be at least, beyond just general interest in the subject, some interest in the court and some sense that among some of the justices that there's a problem with the statute. The court had gotten to the trouble of sending the case to the Solicitor General. The other factor, I think, here is that the court was an epically low number of merits cases as it got to the end of the term. Modern history hasn't seen the court with so few grants, and so I think there probably was a real interest at the very end of the term of picking up something that was obviously quite constitutionally significant, and also the subject matter was interesting. Other questions? In the back left, please.
Hi. You discussed the travel ban case as being a blockbuster, and I'm wondering why won't it be moved since it's a 90-day period?
So, and Elizabeth, you want to talk about it?
That's a great question, and I think that the other possibility is not just the mootness, but also after the administration finishes its review of procedures, we may very well have a different program in place by the time the Supreme Court hears the case in October. And briefing will go on over the summer. before that argument in October, but I do think it places the case in a very awkward position. Especially when you think about the main argument from the administration being this urgent national security. Well, presumably by the time they've gone through their procedures of how they better vet, as Trump would say, figure what the hell is going on. Presumably they're doing that, and by the time the court hears the case, presumably they will have done that. And so it does place the case in a very awkward procedural posture. I think that as those national security urgency points go away, the administration is going to have to ramp up its claims that you cannot review this kind of action, which they made very forcefully and I think erroneously in the lower courts, and they were rejected in the lower courts on those claims. Of course, the claims of the plaintiffs in the case that this is an unconstitutional discrimination on the basis of religion, those claims don't go away. There's still that perceived animus. The administration in court, Jeff Wall has done a great job arguing the case as acting Solicitor General, trying to say that there is a break between the first travel ban and the second travel ban. And then, of course, Trump made his job much harder by tweeting out after his loss that, no, it's the same thing. We should go back to the original one. Yes, it's a Muslim ban. It's going to be, even if it ends up being moot, I still think it's a blockbuster just because it's so interesting and there are so many important principles that are fundamental to both our constitutional structure, our constitutional rights, and frankly, American values.
The other thing I would just add is what's going to be fascinating is if the court does reach the case on the merits, you have these fundamentally different approaches from the Ninth Circuit and the Fourth Circuit. As I'm sure many folks know, the Fourth Circuit was a constitutional holding that included a finding of animus, racial animus, and the Ninth Circuit decided not to get into any of that and exclusively ruled on statutory grounds. So you have two completely different ways of looking at the case. Strategically, one might posit that the statutory approach is the path of least resistance and the more likely one, again, if it's not moot. And I think there's a serious question about mootness.
I agree with Peter that, sorry, Tom, that this will, I think the blockbuster nature of it depends in part on which path they take. And I agree with you that looking at the animus here, particularly looking at Trump's online statements, is a really interesting and new and kind of digital issue for the court. So I'm fascinated to see whether or not they're bold enough to take that. But I would argue in some ways, and Paul kind of alluded to this earlier, that in some ways, and the panel may disagree with me, I think the order is itself a bit of a blockbuster in the sense that it is muscular. It is the court drawing its own line, right? Not based in statute, not based in the executive order, about how this semi-stay is going to be accomplished. And I find that in and of itself pretty astounding, given that it came per curiam, as it did, and kind of set its own interim balance. So I think that's an indicator that the court is willing to wade in to some serious controversy, including making foreign policy itself. So I think that's already pretty fascinating, and it has the potential to be a lot more so, particularly if the Fourth Circuit approach comes up to the court.
Yeah, I think the timing thing operates as kind of a one-way ratchet for the administration. They have a lot of power now to modify it, to abandon it in substantial part, to ratchet something else up, and thereby kind of reshape the controversy and maybe avoid the Supreme Court with respect to things that they think they're most at risk for, so long as if somebody can keep the president quiet, however unlikely that is. The other thing I would say is that I think that the travel ban case at the Supreme Court really does highlight the difference between the US Supreme Court and a lot of lower courts. As Elizabeth indicated in talking about the travel ban case, everyone says, like, in the context of the moment, we know what was up. And, Justice Kennedy isn't spending as much time on Twitter as maybe he should. The justices are a little bit more distant from that context and are writing an opinion that isn't going to be kind of rooted in that, I think, in all likelihood. And so I have always had the view that this case was kind of the reverse of the September 11th cases, where in the wake of September 11th, the Supreme Court stayed out of a bunch of stuff. And then eventually, as it got a little bit more distant, they were willing to say that the courts have a role. And then as time went on, really didn't apply that role in any really muscular way. And I think that as the months go by from the campaign, from the election, and the administration is able to roll out, version 2.5 or something of the travel ban, a majority of the Supreme Court is going to kind of look at it on its face. And the administration's lawyers are going to be able to shape something that is, much, much harder to invalidate. And so whatever one thinks of the real politic of the moment, what really is going on behind the scenes, I think at this U.S. Supreme Court, with this Supreme Court majority, it is going to be a significantly difficult fight to get them to pay attention to the context and view that as determinative. So I think the administration probably has the wind at its back. I actually think that the challengers should take more comfort actually from the order that doesn't lift the injunction altogether, but indicates that there are going to be some boundaries. And I also think that there's going to be a lot of collateral litigation over why your fiance is not a bona fide relationship to the United States, as apparently as isn't, or grandparents and the like. The interim guidance that was issued that will go into effect today seems to take a very narrow view of that I really doubt that the justices had in mind. They just really decided to push the boundaries of it. We have time for one last question. Where are you? Here you go. Yep, there you go.
With such an all-star cast, it's hard to resist asking your professional opinion as to whether the current activities of various legal officials in the federal government will turn into a new version of Watergate or drift quietly away. And if the former, what will it be called?
Folks? I mean, all of these controversies do make their way to the Supreme Court, it seems. Watergate itself, stuff arising from the Clinton investigations. This thing is going to have so many tentacles, and I think the president himself and the administration are, have such a muscular view of the president's independent authority that it would shock me if it didn't spawn collateral litigation that spanned the rest of the president's term, and that those disputes weren't significant enough, whether it comes to subpoenas, whether it comes to the scope of the special prosecutor, whether it comes to the termination of the special prosecutor, what have you. It would astonish me if this thing managed to evade spending half its time in the courts. I just think there are serious questions. You have a litigant in the White House who is, absolutely committed to, so far, to not taking this as a matter of compromise. And so it would really surprise me if this didn't just balloon into a number of incredibly important controversies, and one or more of which ended up at the Supreme Court within 2 years. Thoughts of other folks?
Yeah, I mean, I think, in addition to the investigations going on, and I think it's important to remember that, these things take time, and Watergate took time, and eventually, the legal issues played out from there. There are, of course, also the other suits against Trump based on his business dealings. Constitutional Accountability Center represents 200 members of Congress in an emoluments clause suit for his failure to get consent of Congress before accepting payments from foreign governments, as the Constitution's clear text requires. There are 2 other lawsuits already. There are other lawsuits surely on the way, particularly as we start to see housing policy developed that somehow benefits Trump's businesses. So I think that there is going to be a lot of litigation. I can't take credit for this joke, but someone said, Trump's best employment program is for lawyers. So I think that says something.
And I just add that I think it highlights where advocacy is happening in some ways, right? That I think for progressives who view the executive and the legislative as basically locked up by the Republicans, I think there's a lot of hopes and dreams being placed on the shoulders of Anthony Kennedy, assuming those shoulders can take one more hope or dream from the progressive community. And so this has been an interesting term because we have been floating with this 8-member court, and we have had this consensus. And I think Tom's exactly right that with Gorsuch activated, we're going to see a totally different court, and one where progressives may or may not find it, the hospitable branch of government that it at least arguably is relative to the other 2 right now. So I think it'll be fascinating as those trickle up, especially with Gorsuch on the court. We're going to see if the courts remain a place where we as progressives can fight to ratchet up individual rights and liberties, or whether we're going to have to try a new tactic.
All right, tremendous. I'll repeat the panel's appreciation to you all for being here with us and having such good questions and being so attentive. And if you'll join me in thanking the panel.